So you're telling me that this emergency foreclosure coming up in like a week, so that we're going to have to self-perform and maybe try to get the auction date stalled or extended, but at least get the reinstatement amount figured out and paid. All that whole stuff was BS.
Not exactly BS. It was misunderstanding. The wholesaler.
And it's not even under contract. The person that brought it to us wants to buy it, but it's not even under contract from the wholesaler who introduced her to the deal.
Yes, he only has a letter of intent that it's not even signed because it's not even signed because he had one for a different amount, and then he went back to the seller and say, no, you know what, that I'm not going to be able to do, but I can do this. And they say, okay, you have a verbal agreement, but we're not even going to sign this because then you're going to go back and say the same thing or come back with a different number. So no. And that's exactly what he's trying to do because he doesn't want to go lower on his 10,000 that he wants for assignment. So she said, hey, we need to negotiate this because I need to pay the transaction coordinator. And you're telling me the closing cost, it was 2,500, but it's not because that's another commission for the listing agent in that house. So there is a lot of commissions.
And there's an agent involved.
And it is an agent involved. And they want to renegotiate the price because they are not willing to make less than 10,000. So we don't have a letter of intent yet, even.
It's simmering now. It's not ready to go. No pants are on fire, so we can rest. And we're still communicating with her, and she'll let us know when she gets more. But for now, it's not the urgency that was once thought.
And we do have an attorney that can help us close that FHA in Texas. So that's
Tipton.
Yep.
So Tipton is willing to close FHA loans?
Yeah.
Sub 2?
Yeah.
All right.
That's good.
Of course, we haven't been through it yet to find out if there's a rock in the way, but that's what we understand from what they're saying.
Are you a skateboarder?
No. Is that
skateboarder? No, rocks in the way are something that scares skateboarders because a little rock can trip you up.
No.
But we do have an issue with the other house that Tipton is doing for the VA loan. It seems like that we're acquiring from an individual. But when he got it in his VA loan, he got it from another person, but that person would claim his interest on an LLC. But when he sold in his name, not on the LLC. So right now there is a break in the chain of title or title chain or whatever you say that. So they are going to have to fix that and then acquire the property. So the title is cloud. It's not clean.
Right.
But he got it on March 2020. So that's been for the past 2 years.
Oh, okay. Not too bad. I had that happen to me on my flip house. It ended up being delayed by 2 months. The closing was delayed by 2 months while they chased down all these different entities.
Yes.
A bunch of quit claiming between LLCs, and then the LLCs are no longer in existence.
Oh, wow. So that's what we're saying. It's kind of like a messy situation. But yes, it's going to take longer, but they say that they can figure it out.
Yeah, and when you guys come and tell me something about some deal, most of the, I think very consistently, you guys are always coming with information that indicates you've already done your research. And so for me, it's mostly a question, or you're only bringing me questions of what's the most bestest rather than what general thing should I do? It's like, which one of these things is the most bestest thing to do? And I appreciate those questions. That's great.
Thank you.
I like working with you.
Thank you, Caleb.
Hey, we might we might do a house in Georgia and they want us to use their contracts. And I know that that's okay, but how do we extract of our stuff what we want to be in the Georgia contract if we follow through with something like that? You know what I'm asking?
The state realtor contract?
Yes.
I think the key phrase, oh, I have a document about this. Stand by. Drop the link in chat for you. So I have it all highlighted on the second page. We care that number one, that it's assignable. So whenever you're using a realtor contract or a state contract, that's fine because they're generally written pretty well.
Mhm.
I don't want other wholesalers' contracts when I'm TCing. I want my contracts or the state contracts, but it needs to be number one, assignable. And if you get any pushback on that, it's like, listen, we rarely close in the name of the company that we go in under contract with. We either start a new company or we bring partners on and create a new company, or like I've done it where I went under contract in my own personal name or another company name, created an LLC and then closed in the LLC, that other LLC's name. So it's not abnormal at all. And we do need it to be assignable. Number two, I need a long enough inspection period that we can really, like, we can cancel for whatever reason we need. So that depends on the situation though. If you're comfortable with the house, great. Just make sure you take a look at the inspection period. By default, they're usually 10 days from my experience. We're also not looking to put a giant amount of earnest money down, and they'll default to like 1%. The realtors will. So, but
2,000.
why?
Why did they agree?
No,
Yeah.
because no, it is like 1% of the purchase price. So that's what we say. Okay, yes, but after the inspection period is done.
Oh,
So
EMD not due until after inspection period's done?
yes.
I like that. That's it. That's, I mean, it kind of negates the purpose of EMD, but
Yes, but that's why we say, yes, we can give you like 1%, like the 2,000 instead of 500 or 100, but
right.
only after the inspection period. So that's what I
like it.
Okay.
I like that. Escrow, probably 30 days or more, unless there's a good reason for exception.
Okay.
So the escrow period, sorry, so the close of escrow needs to be 30 days or longer. And then we would really like the right to place a memorandum of contract. That's only a major concern if it's off market. If it's an on market deal with realtors involved, I'm not too worried because they're contractually bound when they have an offer that's the active offer that they can't go around it. Like once they've got the accepted offer and all that stuff. So I'm not too worried about that with on market properties. But if it's off market, whoever's paper, we want the right to place a memorandum. And then with realtors involved, we need to clearly understand in the contract who's paying the closing costs and specifically the seller's agent fees or the listing agent's fees.
Okay. In this document, although we didn't open it yet, this document talks about what you're just talking to us about too. Okay. Yes. Thank you.
Oh, the one in the chat. Yeah, it's all highlighted. It's on page 2.
Okay. Perfect. So, but I don't have, so I'm a realtor, but I don't have access to Georgia forms. So he has to do it and just add those requirements for us.
Yeah, make sure that the provisions that are in there are written to your liking as far as like the EMD additional terms and conditions, right? So your inspection period length can be, that's a normal line that they can fill in, not an additional term, but your EMD after inspection period might have to be an additional term and condition. It can literally be a blank page where you write additional terms and conditions and just list them and copy and paste our memorandum of contract phrase and all that stuff. Why are they insisting on the Georgia contract?
What's that?
Why are they insisting on the Georgia contract?
Because he said that his brokerage required him to use those forms.
It's a real.
Is it off market?
No, it's on market.
Oh, okay. I've seen some realtors who are required to use those forms even for off market deals that they're not doing through the brokerage. And that may be from a professionalism / I don't want anything coming back on you and in my name perspective from the broker.
Protection for themselves. That's understandable.
Yeah. Just like I'm familiar with our contracts and I'm going to tell everybody to use ours. Same thing's true over there.
Okay, so what about the cure notice and all those other provisions?
Ooh, that's a really good question. The cure notice thing. So normally the default by the buyer and default by the seller are discussed in those. And due to recent investigations, I have found that not all contracts include a cure period. Ours includes a 10-day cure period, which is pretty dope.
Mm-hmm.
I like it because if somebody defaults, speaking of which, we need to chat about that other situation where somebody's in default and we need a cure notice there. Yeah. If we can get a cure period put in there, especially in favor of our client, I don't care if it goes in favor of the other person because the contract wasn't going to have it in favor of anybody before. So if we just add that, that's also a good one. Let me open that back up. Put that in there.
And also, I was going to ask you, when can we work together to do the additional paperwork that we were saying for SAP 2 paperwork that you like the escrow, and I call it 1098 form?
Which one? What are you talking about?
Do you remember that when we were looking at Harry Marsh paperwork and we say, yes, we should add this one to our paperwork? That you call it escrow escrow form or something like that, but I call it 1098 when we are the ones now claiming whatever in the taxes for the property. So that
You
one.
remember that?
So that one, I want to add it to all the paperwork that we have. So even open to close to put it that one there.
Okay.
Please.
I like it. Can you schedule some time with me to review that for like next week?
Yep.
Anytime in my Monday afternoon is unbooked. Just set 30 minutes. Send me an invite for 30 minutes.
Okay.
We'll just stay in the virtual office for it. I just need time blocked out for that purpose.
Okay.
You did ask questions.
So with regard to our cure notice period, like at some point, you got to keep the word reasonable in mind. At some point, it's going to be unreasonably long period of time that the contract has been incomplete by either or both parties, and at which point it's going to be unreasonable to finish the deal. You kind of need to be able to blame somebody pretty quickly, I feel like, for it to be reasonable. This is my gut. This is not legal advice. I don't know. It's going to be very subjective if it comes to a court case. So I think it's reasonable to issue a cure notice within like a week, probably, of failure to close, and send a written notice that says, hey, you didn't show up to closing. We're ready. We're here and ready, and you need to perform pursuant to the contract. Section 9.1, I think, is default and remedies and cure period. So, or seller default pursuant to section 9.1, I believe it is. You tell me the number later. Then you are hereby on notice to cure your default, and there's a 10-day. You have 10 days to comply.
The one
or
thing,
you'll be in full breach of contract.
you have to redact now. I'm sorry.
No, you're good.
The one thing offered to us from them was, I don't think the guy is going to do email, but if I remember correctly, you said it doesn't even matter if they respond to it. He has email. There has been communication by email. We can send it. No matter what they do with it, we did our part. Is that correct?
If that email address is the email address listed in the contract section 1.8 for the party's contact info. If it does not exist, I don't care if it's in the DocuSign section at the end or signatures period section. If it's not in section 1.8, which is where we define who the parties are and their contact info, then the email is not valid as a means of communication. But if it's listed there, then it is listed as one of the places you can send notice.
I believe it is listed. It is true that he is not.
No,
Okay.
I don't believe it's listed. They have been sending information from the title to that email, but I will just check. I'm checking right now on the.
So that email, his email address may be a matter of convenience for people to communicate back and forth, but contractually, it may not be the place that you're allowed to send notices.
Okay. Well, he hasn't, it's true that he does have difficulty and they have gone to his presence, you know, to the home to get signatures
No.
and whatnot. So no, it's not listed.
No, it's only his name. Okay.
Does he have an address on there?
Yes.
No, in the seller's information, no, it's only his name. No address, no. Oh, yes. I'm sorry.
Who wrote this?
No. Address. Yes, we find yes for address, not for email. I'm sorry. They did. I told you that we begged them to do it for them, and they didn't listen to us. But it's
Yeah.
but it does have the
Well,
address.
So, for the sake of the recording here, that's why this crap matters. That's why you need to have somebody who knows what they're doing filling out the contract, because it sounds pretty close as if they didn't. They almost might not have filled out the information correctly, which matters. Like section 1.8, where you define who the parties are, has implications throughout the rest of the contract, not just the name of the party, but also the mailing address and the email address. And had they made it a priority to collect an email address, then we would have been able to send electronic notices, and that would have been fine. That would have constituted notice. But now you have to either personally serve them or serve them with certified mail.
Okay.
That's what happens in the rest of the contract when you don't understand or require an email address in the parties section.
Okay.
And it ain't no party now, is it?
No party.
Mailing address then. Okay.
And it's got to be certified. So we'll make sure that that's what we convey.
Or personal delivery.
Yes. Okay. They've been doing everything else personal delivery. So
Yeah.
I mean,
Is that in a two-party recording state?
I don't know. I don't know if Washington is or isn't. That's terrible that I don't know because I live there, but I don't know. I just know that when they have meetings.
You said Oregon is though, right?
No, I'm in Oregon, but this one is in Washington.
I know. I'm just asking, you said that Oregon is it? Washington is a two-party consent state. So they could approach with their camera on and say, hey, I'm recording. This is your notice. You're being served. Your notice to cure. We need you to come to the closing table and perform.
Okay.
Okay, and that's the kind of instruction we need to give to them then. They've got to make it clear that they're recording and they're serving at the same time. Okay.
Yeah, that's not legal advice. That's just that's just some dude's idea.
Yeah.
Yes.
Which is most of what this business tends to be. Some dude's idea. How do we do this?
I have something else to ask, but I don't know if it's part of this recording. I don't think it is. It's a different thing. So
I can cut it into pieces. Do you want it off recording or does it matter?
no, I don't care. So it's about the house that we have with Zach. So we had a signed contract, and then the person, he says that he doesn't want the house anymore. So we say, okay, that's okay. We'll find another buyer. So he sent me another buyer. So I talked to them, and it was kind of like, they are pretty picky. They are asking too many things. And the thing is, like, he wants to have, because he doesn't trust us, because it's his first time buying a house, he wants a realtor involved. And he said that it's okay with him to pay the realtor, but he trusts her, so he's okay with that. So she called me and she was asking me, is this a wrap, the thing that you're doing? So how should I explain what we're doing with a sub to transaction to a realtor? Do I explain everything that we're doing? Because I have a call later today with her. Like, he is acquiring in a sub to, and then he's gonna sell it to him. So I don't know if she's gonna be concerned
On a
about
wrap?
on sale. Yes. Should I
If
explain?
she's asking if it's a wrap, start with that and say, yeah, it's a wrap. We're wrapping the underlying financing to the end buyer. There will be an acknowledgement of a potential due on sale clause. However, wait, so is this a double close or
Yes, it's gonna be like a double close because you remember Tipton doesn't want to do the wrap in one transaction, so it's gonna be one close and then. So technically,
Well-
I don't know if it's a wrap or not.
is it two contract for deed wraps, or is it a outright sale? I'm sorry, like a deed transfer where it's actually a purchase on the first leg and then it's a contract for deed on the second leg?
No, it's not gonna be a contract for deed. It's gonna be the deed transfer.
So the first leg is actually a deed transfer. It's a sub two
Mm-hmm.
plus maybe some seller finance, right?
Yes.
So that's a hybrid. Okay. So we have a hybrid on the first leg and the second leg is going to be contract for deed, right? No, that's in Texas.
It's in
No
Texas.
contract. Yeah, no
No.
contract for deed there.
No.
Okay. Yeah. So it'll be a wrap. Yeah. It's going to be two full purchases under wrap. Deed
Yes.
transfers under wrap, which will include an acknowledgement of a potential due on sale clause. And you should put your contact info on that documentation in case they have an issue and they need to call somebody to fix it.
Okay. Okay. So I guess they will, if there's like a due on sale, like I'm sure he's gonna call Tipton. And I guess she's gonna contact us.
Exactly.
So I don't think we are like leaving them alone. It's okay. Okay, so that's my question because she was, they are like betting me, like me. I say, you are selling this. And I say, no, I'm not selling. I'm just helping with the transaction coordination. That's the thing that I'm doing because, I don't know. She's like, oh, we need to be sure that this is legal and blah, blah, blah. And I say, yeah, I will talk to you tomorrow.
Yeah. It's almost like you forward them to or send them to Tipton's website. My ID. You need ID to get Benadryl nowadays? Dude, what?
Yes. Yes.
What has this world come to?
Not in Oregon, but in Washington too. If you want to buy something like that, yeah.
Oh, and the lights are on now.
Dang. You
You're
have to be
awake.
Oh, I've been awake.
Okay, so, well, that was the question because like you were saying the other day, when does it stop being like a transaction coordinator and when are we starting to perform law or I don't know. So I got like yesterday, just give me, I will talk to you tomorrow because I don't want to be liable for anything.
No, so yeah, tell her to wrap and then see if you can find any resources on Tipton Law Firm's website. They actually have a pretty good website. They've got a bunch of resources, including some of the forms that you'll be using.
Yeah. We're doing
Tipton
fair.
Law Firm. Tipton Law Firm SA.com.
Yes.
Yeah, wraparound owner finance transactions. Yeah. Yeah, there's services, lists, all that stuff.
Exactly. So I can like, I love that you say that we can refer her to that website. So it's there. She can just go and talk to to Allison or whatever. And yeah, it's nothing illegal. Maybe she's not familiar with this, but it's not illegal.
Here's a quote for the books. Just because a realtor doesn't know about something doesn't mean it doesn't exist or that it's illegal. How about that? Can we spread that across the internet?
Oh, yes, I would love to.
Please, just because a realtor doesn't know about something does not mean it's illegal. Quit saying that,
Mm-hmm. Okay.
realtors.
Yeah, how about they just learn to say they're unfamiliar instead?
Yeah. Oh, you know what? I've never heard of that. Let me look into it. Oh, that can't be legal. That's what they say. That can't be legal.
Mm-hmm. Mm-hmm.
That's
Okay,
that doesn't that my contract doesn't show anything about that. Okay.
your contract.
Mine
Yeah.
does.
Okay,
Yeah, that's a good comeback. Mine does.
yeah. Okay, so we will keep on doing this then. What did you find out about the promissory note? I don't think it has to be notarized, right?
The what? The
The
which one?
the one you were talking to Michael when we started. The promissory note does not need to be.
Oh, no.
notarized.
Yeah, we're good. Yeah, I was just looking to see if we need wet ink originals in that state for a promissory note.
Oh, okay, yes.
Colorado's a little weird. Colorado wants blue wet ink originals, even for promissory note.
Blue, yes.
Blue.
And
Blue,
wet.
wet, even for promissory note.
Yes.
And by the way, hello, Charles. I see you're here. The other thing is that Colorado is the only state that appoints a county official as the trustee for all deeds of trust.
Hmm.
You can choose some other party everywhere else.
Hmm.
Nancy's got a comment. I see it.
Uh-huh.
Come on, Nancy, lay it on us. Mr. Charles, do you go by Charles? Charlie?
Yep.
Chuck? Chuckles?
Typically Charles or Charlie.
No, I was gonna say, do you know why they use blue ink?
Why?
So they
can
know
tell
it's
what
the
originals.
original.
Uh-huh.
Yeah.
Instead of
A copy.
black one. Uh-huh.
Let's start a new state that uses purple ink.
There are certain states that you can use whatever you want. That they will allow that. We've had blue,
right.
we've had pink, we've had teal,
Nuh-uh. Pink?
pink.
No way. Amanda would use pink, wouldn't you?
Yep.
I can see it in her video. Oh, all these cute colors. Charles, let's hit a breakout room, bro.
Okay,
Let's see.
I don't know how to do that.
Oh, are you on? I should be able to invite you to one. So I'm going to invite you to room 17.
Numbers today.
No, not all. Hold on. So let me see if you get a notification on. You're on mobile.
Yeah. Yep, there it is.
So, okay, I'll see you there. I'll wait for you to join, and then I'll join you. Looks like he joined. Peace out.
See ya.